Do you have a right to record people in public? A recent case out of Oregon asked that very question. Can states restrict who and when people can record conversations in public? An Oregon law prohibiting recording public conversations except in certain limited circumstances was challenged by Project Veritas. As is often the case, both the legal challenges and the judicial opinion make some questionable constitutional claims. This is why we're going to look at the opinion of the Ninth Circuit Court panel and decide for ourselves. Does recording the public conversations of others violate the law, or does the law violate the Constitution? So we'll do that next on the Constitution Study.
Love your neighbors and have a few good friends. Every day we're everyday Americans. Oh, every day we're everyday Americans.
Hello there, everyday Americans. Paul Engel here with the Constitution Study, where we read and study the Constitution. Teach your generation be free. And I'm glad you could join me today. It's an interesting conundrum in this particular case, and I think it'll have a little, we'll say, interesting twists along the way. If you want to find out more about the Constitution, we'll just visit the website, constitutionstudy.com. I'll talk more about the website and some other things we have going on at the end of the episode. But for now, let's take a look at this Ninth Circuit panel's case about this Oregon law. Here we have an interesting situation with tension between two apparent rights. It's not just the rights mentioned in this case, the right to privacy versus the right to operate a recording device. Oregon law generally prohibits unannounced recordings of conversations, subject to several exceptions. We conclude that Oregon's law is a content-based restriction that violates the First Amendment right to freedom of speech and is therefore invalid on its face. Oregon has a law prohibiting unannounced recordings of conversations. This could open up a rather large can of worms, since everything from security and body cameras to casual recordings of others could be implicated. However, I want to start with a statement that it violates the First Amendment. The Ninth Circuit claims that Oregon's law violates the free speech clause of the First Amendment, which reads, Congress shall make no law abridging the freedom of speech. The first problem we run into with this case is the fact that the law in question is a state law and not one made by Congress. Therefore, it cannot violate the First Amendment. If this were a free speech violation, it would be of Article 1, Section 8 of the Oregon Constitution, which reads, No law shall be passed restraining the expression of opinion or restricting the right to speak, write, or print freely on any subject whatever, but every person shall be responsible for the abuse of this right. That leads us to the second problem. See, the law does not restrain speech, but the collection of speech. From the case we read, the First Amendment, applicable to the states through the 14th Amendment, provides that Congress shall make no law abridging the freedom of speech. While the First Amendment literally forbids the abridgment only of speech, the Supreme Court has long recognized that its protection does not end at the spoken or written word. Once again, we see the courts, especially the Supreme Court, simply making things up as they go along. The Constitution says one thing, but the court decides it means something else. For example, the courts claim that the First Amendment is applicable to the states through the 14th Amendment, but that amendment says no such thing. It reads, No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. The 14th Amendment says nothing about changing the scope of the First Amendment. This is simply made up by the Supreme Court, I believe, to promote an agenda of federal supremacy. Furthermore, the court points to the First Amendment, which says the freedom of speech shall not be abridged, even though the Oregon law does not abridge freedom of speech, but the recording of speech. From the opinion, we have recognized there is no material distinction between the process of creating a form of pure speech, such as writing or painting, and the product of these processes, the essay or artwork, in terms of the First Amendment protections afforded. Once again, writing and painting are not speech, but publications. That means they would be violations of freedom of the press, which Webster's 1828 dictionary defines as the art or business of printing and publishing. The court further obfuscates the issue. Indeed, we have never seriously questioned that the process of writing words down on paper, painting a picture, and playing an instrument are purely expressive activities entitled to full First Amendment protections. There's a difference between writing down your own words and those of someone else. Even by their own twisted view of the First Amendment, they have not found a protection of the right to record the speech of others. The court did find a constitutional violation, though, just not the one they claimed. This general rule is subject to numerous exceptions. Two are relevant here. First, Section 165.5401C does not apply to persons who record a conversation during a felony that endangers human life. Second, Section 165.5401C allows a person to record a conversation in which a law enforcement officer is a participant if the recording is made while the officer is performing official duties and meets other criteria. It's actually the exceptions that the court will focus on, not because they are violations of the Constitution, but of Supreme Court precedent. Because we must determine the constitutionality of Section 165.5401C under the First Amendment, we next turn to the question whether it is content-based or content-neutral. This idea of content neutrality was made up by the Supreme Court in order to allow governments to infringe on free speech, as long as they were equally suppressing the speech on all sides. Because we conclude that Section 165.5401C and its exceptions constitute a content-based speech restriction, we can uphold the statute only if it survives strict scrutiny. Here we arrive at one of the Supreme Court's most egregious violations of the Constitution, the modern interpretation of judicial review and strict scrutiny, which the Free Legal Dictionary defines as a standard of judicial review for a challenged policy in which the court presumes a policy to be invalid unless the government can demonstrate a compelling interest to justify the policy. The court is claiming that, assuming the policy is invalid, that it's unconstitutional unless the government can show a compelling interest in violating the Constitution. That means the current application of judicial review, as opposed to the original understanding from Marbury v. Madison, is not only a violation of the judge's oath to support the Constitution, but a violation of the supreme law of the land as well. Now, that's not to say there wasn't someone who disagreed with the rest of the panel. Circuit Judge Christian dissented, saying, "The right to speak and publish does not carry with it the unrestrained right to gather information. My colleagues do not consent that Oregon has a significant interest in protecting people from unannounced recordings of in-person conversations, but they rewrite the state's articulated purpose, the purpose Oregon advances." Judge Christensen is right about a couple of things. She includes the right to publish, the freedom of the press, in her dissent. She also points out that there's a distinction between expressing ideas and gathering information. It's the ability to gather information that's at the heart of this case. Does the state of Oregon have a legitimate interest in protecting people from unannounced recordings of in-person conversations? That's actually a very simplistic way of looking at this case. Americans often talk about a right to privacy, but again, contrary to the beliefs of the courts, that is not a right protected by the Constitution. Before you start screaming about the Fourth Amendment, remember what it says. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. What right to privacy do you have when you are in public? Can your image be recorded? If so, why not your speech? Does it make a difference if you are recorded by, say, a government actor or by a citizen? What if the person doing the recording is a participant in the conversation? These are all questions that seem to have been ignored by the state of Oregon and the Ninth Circuit. Since almost all federal judges have abandoned their oath to support the Constitution in favor of a slavish devotion to whatever the 9 high priests in black robes say, we end up with opinions like this. Reading Section 165.5401C as a whole, we conclude that it is a content-based speech restriction that cannot survive strict scrutiny because Oregon has not asserted a compelling government interest and because the statute is not narrowly tailored. The statute is also not a valid time, place, or manner restriction because it does not leave open ample alternative channels for communication. Applying Oregon law, we may not sever the exceptions because severing them would not render 165.5401C constitutional. Accordingly, we conclude that the statute is facially unconstitutional and the opinion is reversed and remanded. The court finds the law unconstitutional, not because it violates the Constitution of the United States, but because the state of Oregon didn't satisfy the court that it had a sufficient reason to violate it. Which brings us to the question we should be asking. Do we have a right to keep private what we express in public, and if so, to what extent? For example, if you tell me something, I can testify to that conversation. Why can't I record the conversation, either to supplement my memory or to report on it to others? That's not to say I should be allowed to eavesdrop on others' conversations and use that against them. If there is any constitutional basis for a right to keep private what we express in public, I think it would fall under copyright, the laws for which are regulated by Congress, not the state of Oregon. Article 1, Section 8, Clause 8 reads, the Congress has the power to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. You have a right to your own words, including how they are used. If you share them in public, though, can you really be surprised that others might remember them, either mentally or electronically? One thing the court and I do agree with is the unequal treatment this Oregon law establishes, which makes it a violation of the 14th Amendment, not the First, which reads, nor shall any state deny any person within its jurisdiction the equal protection of the laws. The Oregon law grants law enforcement the legal authority to record others, but not the everyday citizen. While the court had an issue with the exception for the recording of a felony in progress, I do understand the logic behind it, if not the actual application. For example, say you see an argument and start recording it in case it escalates to a felony. Then the criminality of your actions are completely dependent on whether or not someone else commits a felony. Does that sound just to you? For all these reasons, I believe the court came to the correct conclusion, just for the wrong reasons. That seems to be quite a repeated term here. The court came to the right conclusions, or partially right conclusions, just for the wrong reasons. It's because we've detached the law from the courts. See, originally we had courts of justice. Then we called them courts of law. Now they're courts of opinions. Their decisions are not based on what the law actually says or what the Constitution actually says, but what others before them, the opinions they have delivered. And that's a very dangerous place to be. Now, I'm still a little shaky on this law and on this opinion. Part of me understands the need to, keep things private. If I'm having a private conversation on a public bench, should somebody else be able to record that, say with a parabolic microphone, and then use it? On the other hand, if I'm having a private conversation with someone in a public place, do I have the right to record our conversation? Do I have to get their agreement first? And what does that do about keeping government and other actors legally accountable if they have to be told, excuse me, I'm going to be recording this, don't say anything incriminating? Kind of a catch-22. So one of the reasons why I look for the nuance. There's a lot of nuance in this, and I think we should use that as Oregon and any other states try to rewrite such a law. I hope you found this a little intriguing, a little thought-provoking, because that's kind of what we're trying to do here, is get people thinking and not simply reacting based on emotion or what somebody says. If you want to find out more, again, head to the website, constitutionstudy.com. You can find out everything we're doing here. You can ask a question. You can buy a book. You can sign up for a mailing list. Most of all, you can try out for the Patriots program. Patriots is our invitation-only program. To get invited, you start with a boot camp. Go to the website, click on Patriots, and you'll go to the Patriots page, and you'll be able to take the boot camp. It's a 1-hour boot camp. It's absolutely free. If you pass the boot camp, you'll most likely get an invitation to join the Patriots program. This program is just getting started. We're still developing a lot of content, but it's got some really great bones. There's some really great things that we're getting started with. So please check that out against constitutionstudy.com/patriots. I also hope you'll come back and join us here next time for the Constitution Study.